Good morning and welcome to the District of Columbia Court of Appeals. We have one case on our calendar this morning, 24 CF 184, TIAQUANA Chandler versus the United States.
Morning, Your Honors, and may it please the court. Adrian Madsen on behalf of appellant TIAQUANA Chandler. I'd like to reserve 3 minutes for rebuttal. I'd like to start with Ms. Chandler's confrontation clause claim and discuss why that, contrary to the government's argument, that is preserved, a point that is underscored by Smith versus United States, which the government cites in its brief, 414 Atlantic 2nd, 1189. And I'd like to briefly just begin with.
Can you just, I'm sorry to derail you. I don't understand why you call it a confrontation clause claim. In what sense were you prevented from confronting the witness?
In the sense that, as I think the passage from Smith would reveal, that is, it is no answer to say the defense counsel's opportunity to cross-examine the witness at trial in front of the jury cured any possible constitutional infirmity. Without having an opportunity through cross-examination to challenge the government's effort to demonstrate competency during voir dire, defense counsel was forced to choose at trial between pressing Latita Sims, there a child witness, about her capacity to tell the truth and to recall events in 1973, as he would have during voir dire, and taking a less severe approach toward her in front of the jury, the course he chose at trial. This was fundamentally unfair since it put the defense in a position of having to risk jury hostility in order to ask the kinds of questions commonly used to ferret out a child's inability to perceive or tell the truth or to recall long past events.
Is that so? I mean, give me the citation again, because I don't know if I've. That strikes me. No, it's possible we've just mislabeled this claim. That strikes me as a mislabeled claim if you call it a confrontation clause. Like everything that you just said sounds like a due process kind of claim.
Your Honor, it is ultimately a due process claim. My point is in saying that in Smith, what happened, and maybe the facts of Smith would be helpful, that is, the court allowed a pretrial voir dire of a child witness. The court inquisitorially did that, also allowed the government to do that, did not allow the defense similarly to inquire. And the point here is that what we had is, during the timing of trial, that is, this is a disclosure that was made for the first time on the second day of trial. The government disclosed this sort of secondhand information that which was shifting at times in terms of what the diagnosis was. Ms. Chandler would have been forced to ask what certainly could have been perceived as indelicate questions without any ability to complete any impeachment, with no expert there. And so that is through the trial court's actions, that is by denying the voir dire and by denying to authorize issuance of a subpoena for the records, Ms. Chandler was unable to put any of that before the jury in a way that wouldn't pose the same risk that this court found persuasive in Smith. Does that answer Your Honor's question?
Yeah, I think I still don't get it. I mean, in the sense that it just doesn't sound like a confrontation clause issue to me. It sounds like a due process issue, but maybe the label isn't terribly important. I mean, I appreciate the point that you are putting a party in a somewhat unfair position, especially, it would be a very odd cross to really go at somebody's competency in something that you might be entitled to do outside the presence of the jury. To me, I would just not call that a confrontation clause claim. That sounds like a due process claim if it's constitutional in nature. That's all.
I understand Your Honor's point. I guess ultimately where I see it as a confrontation claim is that, and I agree, maybe the label isn't particularly important, but that the jury did not hear about this prototypical form of bias. And the reason they didn't hear about it was because of the trial court's actions.
Mr. Madsen, so the jury had already been sworn at this point, is that right?
That's right.
Okay, so I understand if this is a constitutional question, it might be a different calculus, but with respect to versus an abuse of discretion question, but either way, with respect to the trial court's balancing of, making its decision on what to do at this point, was there any discussion of what, I mean, I realize a competency voir dire itself probably could have been done relatively quickly outside the presence of the jury, but certainly with respect to the subpoena issue, which I know is you haven't gotten to exactly yet, but was there any discussion of what that would have entailed in terms of continuing the trial or any of that?
there was not discussion, I will say, to answer Your Honor's question directly, of what that would have entailed, but a reason why a continuance in this case would have not been, why a continuance would have been impractical is, one, it would have required at least a 2-week continuance under 14307. That is, under 14307D, you have to provide the victim 14 days notice. And we had what ultimately was in terms of the evidentiary portion of the trial, a 2-day trial. And as Your Honor indicated, the jury had already been sworn, and Ms. Chandler, like all people, had a valued right to have her trial completed by that tribunal. And so the government argues in its brief that Ms. Chandler didn't request a continuance, but I think it sort of strains credulity to say that the court would have granted a continuance in any event. That is, to continue a trial that had already been where the jury had already been sworn for 2 weeks over a 2-day trial seems somewhat unlikely to me.
But so how does that, I guess I'm confused. How does that support, or maybe you're just answering the question directly, but how does that support your view of what the court should have done with respect to at least the subpoenas?
Your Honor, the court, my point is that the court did not do anything with respect to allowing in a manner that is required under this court's, even under the abuse of discretion standard. That is, I agree that it would have been somewhat impractical and the process would have played out. We didn't end up there because the court didn't authorize the issuance of the subpoena. But the only thing the court did was hear this secondhand subjective proffer from the government. Ms. Chandler had not had any opportunity to speak with the complainant herself directly. And the only thing—
I guess just to put a finer point on Judge Schenker's question, or to follow up, his question was perfectly clear. Are you giving up your argument that the court should have subpoenaed or authorized a subpoena for the records? Because it sounds like what you're saying is a subpoena would have been infeasible. So,
I'm saying it would not have. I agree. I don't think Ms. Chandler is to be faulted for requesting that the court authorize issuance of the subpoena. My point is in saying that I guess I was responding more, perhaps inartfully, not to Judge Schenker's question, but the government's argument that Ms. Chandler didn't request a continuance, and the point being to say that a continuance almost certainly would have resulted in a mistrial, and where the jury had already been sworn, that Ms. Chandler shouldn't have to choose between having the valued right of having the first tribunal completed and this.
You have a separate claim of the court should have authorized the issuance of a subpoena, and it seems like the logical outcome of that is that the court couldn't have because it would have taken too long, and so you were entitled to a mistrial at that moment when the court—
Well, to be clear, Ms. Chandler wasn't requesting a mistrial. That is the
I understand. Right.
I don't think, again, I think the point is to say that I understand there's the freestanding claim, but the trial court didn't take, this was an action that the trial court could have taken. It did not, leaving aside the fact of what impact that may have on the trial.
Your argument then that this just made the voir dire all the more critical? I
certainly agree that the voir dire
was sort of wrapped up with, and we need the records to be able to, intelligently question her.
That's right. But again, I don't think the timing of this was not on Ms. Chandler, right? The timing of this was on the government. I don't think Ms. Chandler is forced to say that because getting the records would have taken an amount of time the trial court may not have given, that somehow that means that—
What do you mean by the timing of this is on the government?
I mean that the government disclosed this for the first time on the second day of trial. That is, there was no disclosure.
Was any sort of Brady argument made of, this is your witness who has these weaknesses that are, clearly knowable to you with some not very difficult investigation. You had a duty to investigate this witness and you didn't, and now you're bringing this to us now?
Your Honor, there was not, that is, the government's representation below was that it had just learned that on the second day of trial.
I know that it had just learned it. The question is, was any argument made that they should have learned it before? Because under, I think it's Kyle's, right? They have a duty to investigate.
No, there was not, Your Honor, to answer your question directly.
Can I ask, I mean, when I look back at this, one reaction I have to this argument is I think there is virtually no chance that Miss Johar would have been barred from testifying due to the lack of testamentary capacity. That's just a very high bar. We have, you know, young children can testify. I just think she would have, and I wonder what your reaction to that line of thinking is. Do you have a case you want to point me to where you think, well, look, this is on par and they did say no testamentary capacity, or, you know, judge, don't think about it that way. Like that's a harm question. I mean, it might be a harm question, but why couldn't we just skip to, you know, we look at the record, we read the testimony. She seems to understand from all sides, you know, basics of what the truth is and what a lie is. None of this was going to matter.
I think what that leaves out, Your Honor, is, and, you know, so the government sort of says, you know, coming back to where we started here, the government says, you know, this is, it's not preserved because Ms. Chandler didn't sufficiently identify this as a credibility issue. But I think where that fails, if we see the trial court's reaction, that is the government describes this, including in this court, as a credibility issue. It says that the trial court viewed it as a credibility as opposed to a competence issue, as Your Honor is saying. And so the notion that that Ms. Chandler didn't, that somehow the government argued this and somehow the trial court came to this conclusion. And the reason I say that is even if we assume for the sake of argument that we clear the bar of competency, it doesn't get us past what may have impacted her, significantly impacted her.
We've drawn the, sorry, go ahead.
Just let me make sure I understand the answer. Forget about testamentary capacity. What you're saying is if we had been provided an opportunity to voir dire her outside of the jury's hearing, then we would have known what the answers to those questions were. We would have known what kind of stuff we could have tested her on, rather than having to wing it in front of the jury where we might just look like we're badgering somebody with a mental disability, and we could more targetedly, we could target our cross-examination in a much more effective way than what we were stuck doing, which was trying to avoid such a bad look as smearing a witness with an apparent mental disability.
That's correct.
Is that right? Okay. I didn't understand that to be your argument from the brief. I'll reread it and see how I missed it, but okay.
Your Honor, and so even if the court were reviewing under abuse of discretion, that is the court did not take any actions here aside from hearing this secondhand, you know, subjective and changing proffer from the government, which didn't satisfy its duty to conduct an inquiry into the facts and circumstances relevant where there is a red flag bearing on material competency. I won't reiterate all of the cases cited in the brief, but just that in some cases may and in some cases must include production review of relevant records, an opportunity for voir dire.
But Mr. Madsen, I'm drawing on Judge Deal's question. Our case law talks about, in order to, I guess, reverse, we have to find unmistakable evidence that the trial court erred on this. And the case is a little confusing because it seems to fold that into the merits question as opposed to making it sort of a harmlessness inquiry, but it strikes me as ultimately a harmlessness inquiry. So is it your view that that harmlessness type of analysis does not apply if this is a confrontation or due process issue versus a standard of abuse of discretion issue?
So on confrontation, I think as discussed in the brief, that we'd be operating under Chapman here. That is, you know, the government would have to show harmlessness beyond a reasonable doubt. And under abuse of discretion, I agree, it is a strange inquiry because it sort of does blend the harm. I'm not quite sure how to unravel some of what is a strange function of that case, except to say that even if we were reviewing for non-constitutional harm, in the standard case, I know we have this unmistakable evidence quotation that the government relies on here. That's ultimately traceable back to this 1973 DC Circuit case that sort of is without citation to authority. It doesn't seem to me to be any sort of reasoned heightening that somehow unmistakable is different than what we would usually be operating under for non-constitutional.
Right, but I guess-
TIAQUAS.
Sorry, I guess ultimately the question, again, this is kind of what Judge Deal, I think, was getting at, which is, let's say we think the trial court could have done X, Y, and Z and should have done X, Y, and Z, but it didn't. So we've got the transcript of Ms. Joer's testimony and we look at it and assume, we say, she was sufficiently competent, she testified with sufficient competence and comprehension of the questions. And so why doesn't that lead to an affirmance on this issue?
Well, because we still don't have, again, that is the assumption based on the existing record. And while I understand the court might affirm on competence, that doesn't compel the same result with regard to credibility as just discussed with respect to Judge Deal's question, right? We, even sitting here today, right, we don't actually know the nature of the facility where the witness was. We don't know whether she was taking any medications. We don't know anything about sort of maybe intellectual functioning tests that may have been done. And the reason we don't know that is because the trial, Ms. Chandler could not do that on her own and needed the trial court's authorization. I think even if the court looks at the, assuming for the sake of argument that the court looks at the transcript and said there's not unmistakable evidence that of issues bearing on competency, I don't think that answers the question as to credibility.
Can I ask, if there had been a voir dire on competency and the trial court said, I'm satisfied that Ms. Joher is competent. I had thought, correct me if I'm wrong, that the trial court could then quite properly limit your cross-examination if you started getting into issues that raise competency, and they could say, that's a matter for the court. Mr. Madsen, I'm not going to allow you to attack this witness on her mental capacities because that's already been settled as a matter of law that she's allowed to testify. Don't go down that road. Am I wrong? Is it always fair game to call to kind of bring in the mental health of a witness that has been deemed competent, or is that kind of stuff that's properly relegated to the threshold inquiry of competency?
I think you're correct to say it's not always fair game. I certainly don't think that is the standard. But I think there are many issues, and I think this case presents a good example of them, where issues that might bear on competence also bear on bias. There's cases cited in the brief here describing mental health or mental illness as a form of bias. And so I don't think that would have cut off the inquiry here.
We have cases discussing mental health as a form of bias?
Mental illness is a form. I'm happy to.
Yeah, no. Give me a couple. Do you remember? No, I'm curious to read them. That sounds like a strange proposition to me. So
if I
might just not be thinking about it the right way. So I'm curious to hear what we've said.
I mean, that is there. I mean, if you think about, bias not meaning the inclination to slant something in favor of a party, but just on, ability to perceive, ability to recall, it often falls squarely within that. But yes, there are cases that are cited in the brief. I'm happy to.
I can certainly imagine dementia being, fair game in terms of recall ability. So I get that line of thinking. But okay, good enough.
Very well. I'd also like, I see that I am out of time if I may discuss other claims. The trial court also abused its discretion by failing to order a physical examination of Sean Watts, the second witness here. The facts that support that were Mr. Watts conceded by the government below, a recent history of PCP use, slurring his words, long pauses after questions, often an inability to answer basic questions. The government relies on.
One thing I don't understand from your brief about this claim is what you think would follow from a positive test. You could cross-examine with it?
Sure, absolutely. He denied the use, right? And then to complete the impeachment, I think certainly that's relevant both to his credibility, but also, in several decisions, this court has talked about, PCP being this mind-altering drug.
Sure.
And, in terms of what he recalled.
You don't think you could effectively cross-examine him without that test? We've heard the tapes, and I should apologize to Mr. McGovern because I think we granted that motion before we even got his opposition, and I think we should have waited for it. That was our mistake. I think it was, so we've heard the tapes. I mean, doesn't sound good. It sounds like, it sounds like you could do a lot with that witness, without getting a test.
Sure, but I mean, one, it was put to him directly, and his answer was no, right? And I think certainly a test, if the witness had denied it, and then the test says, I mean, I think that creates.
Well, but I mean, that's a state of affairs that would not have been in play, right? If you had already gotten the test, he might not have denied. I mean, we don't know. Well, go ahead and answer the question, but I have some follow-up questions.
Well, I mean, I take the court's point, but I mean, we don't know whether he would have denied or not based on the test, right? People don't always act, even if he might have known what the test result of that be, that doesn't mean he would have not answered the question in the same way that he did in denying it.
So can I just ask you how this, and maybe your answer is this, again, similar to your answer with Ms. Joer, that it's not really Ms. Chandler's place to answer these questions, but how would this have actually played out? So his testimony had already started before you came to the view that he needed to be tested, right? Am I right?
Correct. Yes,
Okay,
it was
so
after his direct and seeing him on the site.
Right. So, I mean, again, a continuance presumably would have been required, a substantial one. And then
I disagree with that. I mean, he could have gone downstairs to the court and they could have had the result the same day.
Okay, so you're talking about a court-ordered, marshal escorted. What would have happened if Mr. Watts had said no? I mean, maybe again, you're free to answer that this is not before us right now, but I just don't, I'm trying to figure out how this would actually play out and how that relates to the trial court's sort of discretionary decision whether to order this or not.
I guess a couple of things. One is I agree it's not before the court. Two, I think the trial court recognized that it had the authority, and I don't think that the government is disputing that it had the authority here in terms of what, in practice, what might happen if he refused. I think that the same would be with respect to any court-ordered examination for a witness that is refused. That is, he could potentially be held in contempt. But again, that's sort of a state of affairs that we didn't get to because the trial court didn't order it. But in terms of the practice, assuming everything went according to plan, I think it could have happened the same day.
I mean, I guess the way it is before us, in a sense, is when we are figuring out whether the trial court, erred in making this determination, this calculus weighing in balancing sort of the benefits and downsides of ordering this, then we would have to look at all of those factors that would have had to come into play in enforcing this test versus the basis for it. And so I guess so we're looking at how strong the basis is. And I guess that's where we just all come to a disagreement, or you and your colleagues on the other side come to a disagreement based on the transcripts and the audio recordings. But
correct. Right. I think we just disagree about
And
that.
what is it that you think, I mean, I listened to the audio myself, but what is it that what's your big takeaway from the audio that you think shows that he needed drug testing?
The slurring of the words.
Drug testing was warranted.
The slurring of the words, the often long pauses between question and answer, something that sort of can't be conveyed in the transcript other than a characterization of that way in general. In response to some questions, there was, I don't know, maybe 10-15 second pause, and then he says, "What was the question again?"
I mean, sometimes he pauses for so long, he cannot remember the question. He cannot remember information that seemingly you would expect him to remember that he just testified to minutes before. But there's no point where he's giving non-responsive answers or, indulging in flights of fancy or, and maybe that's, a stereotypical understanding of what someone who is under the influence of these substances might experience. But he is, I mean, to the extent that he is able, he is responsive.
I would agree with the flights of fancy. I mean, there are some questions certainly when he answers a different question than was asked, but I think it's more so the very long pauses and inability to remember combined with the I think what is quite clearly the slurring of the words. And so I don't know if that answers Your Honor's question in terms of the sort of unmistakable evidence.
Like whether the juice is worth the squeeze, right? Because here you have the situation where he's clearly has some cognitive impairments. I mean, just given his presentation on the stand, and you have him denying drug use recently or that day. But the jury sees what the jury sees, and maybe you get back the drug test and it's negative.
Maybe.
But this is kind of the best of both worlds of, he seems to be impaired, whether it's by current drug use or a lifetime thereof. And he is unable to recall information, recall names of people that he seemingly knows quite well. He can't remember questions that were posed to him minutes ago. That seems just pretty powerful to me.
I agree it is powerful. However, and I think not to put the trial court in the shoes of the jury, but the jury may have also, I mean, the trial court said, well, maybe he had some head injury, right, as a result of this, and the jury also heard the same evidence that he had these scars on his head. So maybe, right, I'm not saying it's 100% one way or the other, but the jurors also may have drawn an inference that this was. And I know this is outside the record, but I believe the trial court described it at sentencing, so I think we have it in the transcript there. Mr. Watts was also moving very slowly in addition to all this, which the trial court attributed to having the severity of the injury to his leg. So what I mean to say is, based on his presentation, the jury may have believed that some of that could have been attributable to a head injury, although I acknowledge, as the trial court ultimately did, that there was no evidence of that.
Was there anything in the record, and I'm not saying that you had to have this, but was there anything in the record where anyone noted his physical bearing on the stand otherwise, in terms of slouching, falling over, nodding off?
There is not anything in terms of falling over or nodding off. There are several comments on direct about waiting for him to sit down and sort of other things of that nature that convey kind of the pace he was moving at. But there's nothing in the record about slouching or anything of that nature. If I might just briefly, again, I recognize I'm long over time, but just turn to the sufficiency issues unless.
Only have one case this morning.
Oh, I'm glad to hear that, Your Honor.
That was a joke, not a threat.
I didn't take it that way, Your Honor. So I'd like to turn to the sufficiency claims. First regarding the PFCV, the general rule, as the court is aware, is that in order to convict of PFCV under an aiding and abetting theory, the government must show that an unarmed assailant has taken affirmative steps to aid his accomplice in their possession of a firearms. This court found that not satisfied even by evidence in Parker that an unarmed person, quote, physically subdued a person, absent some evidence that the person subdued posed a threat of otherwise disarming the gunman. We have all the cases cited in the briefs here. We have Lancaster.
I think this is going to come down to, well, is this like Parker or is this like Tan? Because Tan doesn't have much more. Somebody is being held at gunpoint, but there was no direct evidence in that case. The person that was being held at gunpoint was attempting to dispossess the accomplice of their firearm, and we still said that evidence was sufficient. So I assume if you're going to say Parker, the government's going to compensate Tan. So I'll ask them about Parker. I'm going to ask you about Tan. What do you think the difference is?
Sure. In Tan, as the court said in Tan, and I believe in Parker later characterizing Tan, that we had a gang dispute essentially in Tan, in saying that there was a territorial dispute, and this person had every reason for that reason. That is the the third party had every reason to want to otherwise disarm the principal. It sort of seemed to be this inference that they might often be armed themselves. And I just don't think we have that here.
We don't have that here, but I think what the argument would be that TAN stands for the proposition that some sort of external factors prior and separate to the actual physical altercation could bear on whether the victim or the, other victim would be inclined to try to disarm the assailant, right? And so here, arguably, we have the fact that Mr. Watts had earlier in the evening choked Miss Chandler quite severely, is my understanding.
Those are separate incidents, Your Honor. The allegation, at least through and I will say both Mr. Watts denied this, Ms. Jower testified to this, and there was sort of no other evidence. And the government says essentially here that the jury didn't credit anything for Ms. Jower, for which there was an independent corroboration. But what the testimony was that the choking was not immediately on this evening before. The testimony was that Ms. Chandler wouldn't leave the apartment, and that Mr. Watts, according to Ms. Jower, it's a little bit difficult to follow, but in some way forced her out of the apartment. But the choking was a separate incident.
No, of course, that's my point, is that arguably TAN stands for the gang violence or the gang relationship in TAN is also a separate incident, right? I mean, it's a state, it's a prior fact, a prior condition that we imported into the altercation at hand to determine whether that victim might have been inclined to do X, Y, and Z. And I'm saying that arguably the same thing is here, where Mr. Watts has previously shown sort of violent tendencies or reactive tendencies that we could read into this situation, right?
So I guess I see the difference as being in TAN, sort of the at least the way the court characterized it in TAN was sort of this ongoing gang dispute. In other words, the gangs had this dispute before, and they were going to continue to have it after here, right? We have this discrete event that has happened here that in any event doesn't, at least the way the evidence comes out, seems more closely tied to being, escorted out of the apartment that evening than to the strangling. But I see it as fundamentally different, where the point of the gang, I guess is another way of saying it, is the point of the gang is to part of their activity is to control this territory, and so they have this ongoing motive to do this. We had this event that happened, and Mr. Watts ultimately testifies that he doesn't know why they're there, right? That's his testimony about why what the jury found was Ms. Chandler and her son are there. And so I agree it is not, I think we're more like Parker than like TAN, but I agree there is some middle ground there. The government also argues that Lancaster, Cox, and Parker don't control here because none of them involved a defendant who was actively involved in assaulting the same individual in concert, but none of that alters the proof that is required here in terms of maintaining possession of the firearm. And again, there was Mr. Watts didn't testify that he in any way attempted to dispossess or that he would have, but for the actions of Ms. Chandler. In fact, in Mr. Watts' testimony, the only time we hear about the gun is when he is shot, right? There's no sort of description before. We have Ms. Jower saying that she sees through the peephole Ms. Chandler with her son behind her with the gun, and that's aside from after the fact, that's the only evidence of where the gun is. So I don't think it supports the argument that Ms. Chandler did anything to assist Mr. Tucker, at least as found by the jury here, in maintaining possession of the firearm. And I think the facts are even stronger with respect to the well-armed. That is, the requirement that there was no evidence here that Ms. Chandler knew in advance, which is the requirement here for the while armed with respect to the aggravated assault while armed. She was acquitted as of solicitation of ADW. And again, the only specific evidence regarding where Ms. Chandler was when a witness saw a person that the government argued was her son, Mr. Tucker, was in front of him, right? We don't have
But she at least knew that a gun was involved when her son pistol whipped Mr. Watts, right?
Well, so we don't, Mr. Watts doesn't testify that he is pistol whipped. He
Is
testifies.
she on a record, doesn't she tell the police? Or maybe that's one of the jail calls, but
So what-
doesn't she say he was pistol whipping Mr. Watts and then I was beating on him? I mean, it seems.
I don't, so the quote is, and I don't read it as being after the fact, that is, she says, and excuse my language, that the two of them were, quote, fucking his ass up, and then, quote, that thing came out, beaten on him, the clip came out, and I just had to run in there and grab his thing, which suggests that in terms of the timing, that ultimately, if she's running back into.
Well, no, I think that's a different,
That's a
that's a
different
different jail call recording. So early, in a prior one, she said that Mr. Tucker was pistol whipping. I mean, I have it somewhere, but,
But that still doesn't prove that she knew in advance,
no,
right?
it's just, she just has to know in time for her to withdraw from the crime at some point, right?
Well,
Before a continuing possession of the weapon occurs by the assailant.
I mean, this all, one, I think that's slightly unclear. That is some of the cases describe the later continuing to participate as evidence of the knowledge that is required. That is that a jury can reasonably infer that where someone continues to participate, becoming aware that there is a firearm involved, that they can infer that they had the knowledge in advance. But I think the requirement is still that the knowledge in advance. I will sit down here.
Thank you, Mr. Madsen. We'll give you a few minutes in rebuttal and we'll hear from the government now.
Good morning. May it please the court, Michael McGovern on behalf of Appellee of the United States. I think I will pick up where we just left off discussing sufficiency and Parker and Tan. We do believe that the evidence was sufficient for the jury to find aiding and abetting possession of a firearm during a crime of violence, especially under this court's decisions in Parker and Tan. It is clear in Tan, as Judge Deal indicated, that there was no direct evidence that the individual that was subdued there was going to the aid of the individual who was being held at gunpoint. And yet the court found that the circumstantial evidence concerning their relationships was sufficient to find that it was that by subduing that individual, they were assisting in the continued possession because there is a possibility that individual would have sought to dispossess.
So I kind of think of it this way, and tell me what you think is wrong with it. This is a rival gang in Tan, right? And if you're gonna go and rob Tony Soprano, you're gonna want to put a gun on Pauly and Chris Moltisanti. Otherwise, they're gonna make a move. They've probably got their own gun. They're gonna try to stop you. So under facts like that, I'd say, yeah, holding up those two guys is definitely aiding the principal in maintaining possession of their own gun. And I think Tan looks kind of like that. The facts aren't totally fleshed out. I don't know if there was reason to think Queen had his own gun. My guess is if you're in like a turf war, you probably do. And then we've got Parker, where there's none of that. So there's really there's no good reason to think the person who is being held by the accomplice is likely to intervene and try to get the gun away from the principal. So here I ask myself, well, is there any direct evidence that somebody was going to try to take this gun away if it weren't for Miss Chandler's assistance? And the answer is no, I think. And then I asked, but do we just have reason to think somebody was going to try to take that gun away? Like good reason, the reason that could supply proof beyond a reasonable doubt that she aided her son in maintaining possession of his gun. And I think the answer is probably still no, but but what's your answer to that?
So my answer to that is yes.
Uh-huh.
And I'll point you specifically to certain evidence that I think shows that. And so I think as was being discussed with multiple of the judges on the panel, there is testimony that earlier Mr. Watts was choking in a very violent manner Miss Chandler. So we have evidence that he is an individual who does use force when he feels he needs to. That incident was separate from him forcing her out of the apartment, another use of force and a use of force to accomplish means that he wanted. We also have testimony that he was using PCP that day. That was testimony from both Ms. Jor and from Ms. Chandler in her statements to the police. So we know that he's on a drug. And we also know, according to...
We don't know that he's on the drug because he never got drug tested. So, I mean, at trial, and we don't know what his drug status, I mean, he denies it. They say that he was. I guess
If I
the
may,
fact that he is using force to push an unarmed woman out of an apartment is one thing. But the fact that we could infer that he would somehow try to disarm someone who's pointing a gun at him, that just seems very different. And it also just seems sort of gratuitous. Like, who cares that the older woman with a ring on her finger is hitting him about the head? Someone's pointing a gun at him and pistol whipping him. There's no evidence in this case that he's anything other than submissive in that situation.
well, with respect, Your Honor, I think there's one additional thing. There are two things I'd like to point to. One is that I do think it's a reasonable inference that individuals will defend themselves. And
But there's no,
when-
I mean,
I-
you
I
might
think
think
that-
so, but there's nothing in this record, right? Did I miss something? I don't see anything in this record that he made any effort. There's nothing.
there is no direct evidence. That's correct. There's no direct evidence.
So far that he's like trying to get away, that he's trying to extricate him from the situation, that he's pushing back. I mean, there's nothing. It's just.
So if I may, Your Honor, the way that he describes the assault is a simultaneous attack on him. So to the extent that her simultaneous attack inhibited a desire to use self-defense where he otherwise would, I believe that satisfies the standard of facilitating his continued possession of the gun.
But that seems to, I guess, I mean, just to get to a doctrinal point, if that's the rule, then that seems to kind of undermine the aiding and abetting standard, right? Because it's no longer that you actually have to do anything to help somebody possess the gun. It's just, well, if somebody has a gun and you're there too, helping them do the robbery or commit the assault, then you have aided and abetted in possession of the gun. That seems to just upend what we actually have ruled, that you actually have to take an action to help possess the gun.
Well, so I disagree, Your Honor. I think that there is more in that situation where someone is inhibited from using self-defense because of your presence, and therefore is no longer trying to disarm someone they otherwise would, then I believe that you would be aiding and abetting their arming of themselves.
So
their
then if you were
possession.
to,
And so
Where are the facts that this older woman who's unarmed is really helping her younger armed son continue to possess the gun? I mean, I think the young son is continuing to possess the gun because he has the gun and he's pistol whipping somebody. Her presence seems immaterial to his possession of the gun.
So I believe that it is a reasonable inference from this evidence that this is an individual who had been violent, who has been violent in the past with these individuals, not with the son, but with Miss Chandler. I think if you look at, to the extent that we're characterizing Miss Chandler as an old lady, I think that we should review her.
Say old lady, I certainly didn't mean to.
I believe you said an older woman. I apologize if I've.
Older
I
than her
apologize.
son, presumably there's at least, 15 to 20 years between them. So
Sure, but I would direct you to her police interview where there's actual video footage of her and how she describes what she was doing when she was getting the licks in and using her fist and pounding it into her hand, showing that I don't believe that it's fair to, it would be, sorry, a reasonable inference that she was using a good amount of force. And this is additional force that's being used on him. And to the extent, as a doctrinal issue, to the extent the joint attack is inhibiting what otherwise would be self-defense that would be aimed at attempting to disarm an armed assailant, we believe that satisfies the standard for possession of a firearm during combat.
Doctrinally, are you suggesting that a 2-on-1 attack is different? And perhaps you're not arguing for in all cases, but that it's different meaningfully from a 2-on-2 or, you know, a multiple party attack?
Absolutely, Your Honor. And I think it's also important to note, going back to Parker, because I do just want to like look at what this court was looking at in Parker. There were specific facts on which this court found that it would be unlikely that the person subdued would have come to their aid, which was they were easily subdued simply because they laid down just with one smack on the back of the head. And that was noted in the decision.
So I appreciate the point that Mr. Watts had a character that suggests he would have acted in self-defense against at least an unarmed person. I still don't quite, I mean, it just strikes me as a leaps and bounds difference between how aggressive a person can be versus an unarmed person versus when a gun is present. And so to me, the natural inference is, you know, absent some reason to think, you know, we've got gang members who are in a turf war. Most people in reaction to a gun are not going to try to dispossess the gunman because it's a very good way to get shot. But then my follow-up question, so I'd like to get your reaction to that, but then I would also like to ask this. It seems like the government had a very ready way of trying to establish that, which is you could have asked Mr. Watts. Mr. Watts, why didn't you go for the gun? He could have said, well, it's because TIAQUANA was, you know, too many of them. But there's nothing like that, is there?
So no, there is nothing like that, Your Honor. That question was not posed to Mr. Chandler, to Mr. Watts. So certainly that's not in the record. I would also argue that defense counsel was capable of crossing on the exact same issue. And so.
burden of proof, right? We're talking about
That-
sufficiency.
That is correct, but in sufficiency, we draw all reasonable inferences on the evidence
Right,
that is within the
Definitely not
record.
defense counsel's obligation on cross to develop evidence about why, you know, whether he went for the gun, whether he tried, and maybe he did, we just don't know. And, or if he didn't, whether it was because it was a 2-on-1 attack and he just couldn't get to the gun, right? That's the government.
Certainly the defense has no burden, Your Honor, but where the government has established evidence that is sufficient to show beyond a reasonable doubt that a reasonable inference that he may have been, then they could defeat that potentially by asking those questions, but certainly they have no burden in the first instance. I agree.
So, sorry, go ahead.
I wanted to return, I believe, the first part of your question, and I apologize, I've lost my train of thought.
I guess it was less of a question, more just I hear you on the people who want to act in self-defense generally.
Thank you. So I wanted to push, I apologize.
Sure,
I wanted to push back on the
looking
reasonable
for, yeah.
inference that all individuals would not seek to defend themselves against a firearm. Well, what I characterized your question.
I think
Apology.
Unless you have particular reason to think, you know, gang member, somebody who's shown a predilection for being armed themselves so that they will react. Like, I think most people aren't going for that gun. They're going to just take their beating.
So then I think the question is there evidence that this is an individual that perhaps would be in that category? And again, we would point to the evidence that this was an individual who was a habitual, according to the evidence, which should be credited on a sufficiency review. He was a habitual PCP user, and that he was violent on multiple occasions toward other individuals. And I would point you to Ms. Chandler's statement to the police when she describes Watts as, quote, "Dude is strong as blank on PCP." So she specifically says that he has this abnormal strength. He's strong as blank on PCP, and that is at 2048-27 of Government's Exhibit 11, which is her statement to the police.
So what do we do with the facts, the circumstances of this specific attack, which I've only sort of pieced together from the testimony, but correct me if I'm wrong. It sounds to me like Mr. Watts opened the door. Mr. Tucker immediately pistol whipped him in the head. And he basically collapsed because how else would you drag someone out of the door by their feet? So he's prone at this point. And I'm guessing he's been pistol whipped in the head and is probably relatively unresponsive. Of course, I'm reading into the record significantly, but is that not? And so if that's a fair reading of the evidence, then regardless of his proclivities or inclinations to defend himself, can we assume that he was at that point physically unable to defend himself? And how does that play into our analysis?
Certainly, if the only reasonable inference that a jury could draw was that he wouldn't have even had the opportunity to defend himself because of the nature of the way the attack evolved, there is the potential that that would not be sufficient evidence. But again, here we're on a sufficiency review. We don't have to draw reasonable inferences that simply defeat the conviction, but rather we're supposed to draw reasonable inferences in support of the conviction. And Mr. Watts' testimony was that they were attacking him, and he describes this as a joint attack. Mrs. Chandler describes a pistol whipping, and she was getting her licks in too. So I think it's a fair inference from this record that this attack was being jointly occurring, and that he was perceiving it as being attacked with multiple people at once. And again, we point back to the evidence that I have that we believe that you could find a violent disposition or a disposition at least to defend himself.
We'll move on to some of the other points.
Yes, Your Honor. Thank you. I'd like to go to the denial of a voir dire and the denial of the request for a subpoena. And first, I'd like to say that I think it's very important to take into consideration the context within which these requests were raised, because this is a late-breaking development that the court is dealing with for all of the parties. And the court is faced with a request for a voir dire to determine competency.
Is it a late breaking? I mean, why did the government get the medical records from the facility that morning? Why did the government ask for the medical records? Is there anything in?
So it's not my understanding that
why this is coming to light, or why the government has been looking in this direction?
So my understanding from the transcript and the record is that there were no medical records that they were looking at. There was information from an individual who had accompanied Mrs. Joer to the court. These were individuals from the facility that she was staying at, which was a crisis housing facility. And they informed the government at that time, she has these prior diagnoses of which we're aware.
Why are they telling the government that this, like, did the government ask? Like, I mean, it just seems sort of apropos of nothing. Let us just tell you that she's got mosaic Crohn's disease, Down's disease, excuse me, and has some cognitive impairment. Why is this coming up?
So that's not
maybe we don't know.
Well, that's not explored. It's not in the record. What I will say is there was no allegation either below or on appeal that there has been a Brady issue. There's been no Brady violation briefed or alleged. And so to the extent that that was the theory of this case, I think that's been fairly waived. And certainly we haven't responded to that. There's been no factual development of that.
I take your point that there is no Brady issue, but it does inform sort of how things unfold thereafter, right? Like, suddenly the government is in possession of information that it's one of its central witnesses, one of the two eyewitnesses to this incident, has borderline intellectual disability and a form of Down syndrome and PTSD, right? And so now the defense mid-trial is saying, wait a second, we'd like to voir dire this witness, out of the presence of the jury, or, so that we can ask her some pretty sensitive questions that might not play well in front of a jury.
Well,
we'd like some medical records. I take it that this crisis facility is not the facility that diagnosed her or is treating her for these conditions. But apparently, if they have this information, that would suggest that they have the medical records that show why she has these diagnoses. I mean, it's at least worth asking, right? And this is the middle of trial, and it is one of the government's prime eyewitnesses. So, that is why I'm asking why this comes to light, and then whether it informs, I guess my question is, doesn't it inform how the court and the government respond to the defense's requests?
I think that certainly the circumstances under which all of this came to light should inform the trial court as to how to exercise their discretion. They are being faced with an issue that's being raised by defense in a certain timely fashion, and they need to decide how best to handle this. What's also important is what the defense is requesting and how the defense is raising the issue to the trial court. And to be clear, in the transcript where they discuss this, and the entire discussion of this spans from pages 5 to 18 of the November 1st transcript. That is the sole discussion of this issue. And the sole request that is being made is a voir dire to determine her competency to testify. That is the first request. That is what they are discussing.
So I'm sorry to cut you off, but I think I know where this is going. I want to make sure because I just want to kind of segue with Mr. Madsen's argument. So I had asked him, well, if I look at this and I think there's no chance this court is going to find her incompetent, that she's going to be allowed to testify regardless, why doesn't that end the matter? And he raised an argument that I think is a decent argument that, well, we should be able to ask these questions outside the presence of the jury. That way we can finally tailor our cross-examination without tripping into these really delicate areas that might look like we're being like badgering a witness with mental deficiencies. So I'm hearing your answer being that wasn't their argument. They didn't raise any of that for the trial court. That's a new theory. They only raised competency. And so really it is the end of the story if you find that she was not going to be deemed incompetent to testify. Is that right?
That's correct. With respect to how the judge handled that particular request for voir dire. Now, to the extent they are raising some type of argument that the judge should have granted voir dire for purposes of credibility, that's a different claim. That is a different issue, one the court was not fairly apprised of, had no opportunity to consider whether or not they thought, you know what, that would put you in a hard place. Maybe I should give you the opportunity to ask some questions. Whether that would be appropriate or not, then they could discuss whether that was going to be the case. I'll also point out the government didn't oppose a limited voir dire for purposes of competency, just to the extent that we're asking how the parties were dealing with this issue.
The trial court? I mean, because the trial court is the one that's saying, look, you haven't shown to me that she is, there's any sort of competency, you might have questions about reliability, but you can just cross on them. Like the trial court specifically says that more than once. And so to the extent that we have a ruling from the trial court that is saying, you can deal with credibility issues on cross. We have cases that say, well, when the court actually rules on the issue, that's preserved for our review. And why can't we say, wait a second, you don't want to put the defense counsel in a position of confronting a witness that they've never met before, don't have medical records for, don't know how they're going to answer the questions for, and, go on a fishing expedition on cross. They should be able to voir dire this witness who the government has just informed them has this menu of diagnoses before she takes the stand.
Certainly, Your Honor, that just wasn't presented to the trial court. And although
defense counsel didn't say it, but the court said it. The court ruled on it, essentially saying you can cross about reliability.
But if the claim is it's unfair to make me do that simply through cross, defense counsel never said that, Your Honor. Defense counsel never said, I heard you just say. I was talking about competency, and Your Honor, I heard you just say, I can only get into these issues on cross as to credibility. I don't think that satisfies my ability to do this, is putting me between a rock and a hard place. That claim can be raised by defense counsel. That claim wasn't shut down by the trial court. The trial court was flagging that it was going to permit a certain type of cross-examination. Now, to the extent there is a claim, it is unfair to make me do that simply through cross-examination. That claim needs to be presented to the trial court to rule on, and it wasn't on this record. It's just simply not there. I don't believe that the trial court was ruling you can only do this on cross because it wasn't being asked whether it would be appropriate to do it in any other way. So it wasn't shutting that down. And in fact, the trial court was leaving open multiple avenues to revisit these issues if during the course of Ms. Jor's testimony, there were issues that continued to come up. So we don't believe that any credibility cross-examination or credibility claim, however that's styled, due process or confrontation clause, it's confrontation clause in their brief. Again, I don't understand how that fits neatly into that category, but the point is these claims weren't raised, and at most they should be reviewed for plain error. And here, when it's reviewed for plain error, there simply is no prejudice. So, well, let me take a step back. When it's reviewed for plain error, I think if you review, we invite you to review the transcript of Ms. Jor's testimony. I believe all of you have indicated that you have. It's very clear that she is in fact competent. She is able to respond to questions in an intelligible manner. With respect to prejudice as to her credibility, first of all, on plain error, it's their obligation to show prejudice. There's been absolutely no showing that there would have been any relevant records had the subpoena request been granted that would have had any impact or that they would have been able to use. They can't meet that burden here. Second, there's no reasonable probability the jury would have had materially different impression of Ms. Jor's testimony. It is clear that the defense's first of all, the defense's strategy in closing was to highlight Ms. Jor's testimony in order to ask the jury to credit that Mrs. Chandler did not see the gun because Mrs. Chandler was standing in front of her son when they were at the door. That was the only testimony that placed her in a position where she wouldn't be able to see the gun, and the defense counsel asked the jury to credit it in their closing argument. Second of all, her testimony revealed many inconsistencies with other witnesses, internal inconsistencies herself. Third, the jury's verdicts make clear that they did not credit any facts where Ms. Jor was the sole witness for that fact. When we look at the burglary charge, Ms. Jor was the only witness to testify that they pushed their way into the apartment. Mr. Watts testified that he opened the door. Mrs. Chandler stated that the entirety of the attack occurred in the hallway. The only person that had any sort of unlawful entry into the apartment was Ms. Jor. They acquitted on the burglary charge. With respect to the overt acts that were specifically charged, with respect to the conspiracy charge, they did not convict or find beyond a reasonable doubt that they made entry into the apartment. They did not find that Mrs. Chandler threatened the life of Mr. Watts during the course of the attack, another fact for which Ms. Jor was the sole witness. And they did not credit the fact that he was dragged into the hallway, which again, the sole source of that was Ms. Jor. So we don't have a record that supports there would be a reasonable probability that a subpoena for her medical records, which is a high standard, I would also like to note, right? We're talking about Brown, so the trial judge in this case, had they been presented with this issue and had they actually been applying this law, should have said, is this in the interest of public justice? I need to weigh her privacy interests in mental health records or disability records versus the need for this information at the trial. And then finally, there's no reasonable probability that there would be a different verdict, even if you were to fully discredit all of Mrs. Jor's testimony entirely. Mrs. Chandler confessed to the police about each and every element of the crimes that were charged, on which the jury is convicted. There was a contemporary identification by Watts when he was at the hospital of both Mrs. Chandler and and her son as the assailants. Watts himself testified that they were the assailants. And there are photographs of the injuries that were inflicted that were consistent with the injuries that one would be inflicted if one were to credit Mrs. Chandler's testimony, Mrs. Chandler's statement to the police, which was in evidence. If there are no further questions on the subpoena or the voir dire issue, I would like to finally turn to Watts drug testing, just to note very briefly that drug testing is heavily disfavored. There's a presumption against it. I think the panel recognized that the question is what information would they have gotten from this? How could it have been used and how would it have been helpful? Would it have made a difference? Those are the types of interests that are required to be weighed when determining whether or not a physical examination should be ordered. The evidentiary value simply does not approach the privacy interest and the potential for harassment interests that are on the other side of that balancing. And since we're on abuse of discretion here, we believe that should be affirmed.
So I wonder if you have an answer to the question that I asked to Mr. Madsen, which is sort of like when I ask myself, well, what are you gonna, I get that it can be impeachment, but anytime somebody denies something or says yes or no, you could test, if somebody says they can jump 3 feet in the air, you could order a physical examination to make sure that's true, and then you have impeachment evidence if they can't. And, we're not going to order tests like that every time somebody makes a claim. But when it is appropriate, why are judges doing it? I mean, you could hold somebody in contempt, I suppose. You could say, you've shown up here drunk to my courtroom. That is undermining the dignity of my court, and I'm going to have you drug tested so that I can hold you in contempt. What do the cases look like that permit it? Like, why are they doing it?
I haven't seen a case that does permit it. I've only seen cases that affirm where a court has chosen not to do it.
Okay.
I think it should be the rare case that it would be permissible, and that's not the case here. If your honors have no further questions, we'd ask that you affirm the convictions. Thank you.
Mr. McGovern. We appreciate your time at the podium, and we'll hear from Mr. Madsen for just a few more minutes. Thank you.
Starting with the Judge Deal, you had asked about cases describing mental illness as a form of bias. McCrae does that. That is, this is at 133 Atlantic 3rd at 234. In light of defendant's right to present a defense, and given the seriousness of the bipolar disorder and the proffer about Mr. Faison's recent episode of throwing urine and feces at a prison guard, we believe Mr. Parker and Mr. McCrae were at least entitled to an opportunity to show what an expert might contribute in an effort to determine any impact of Mr. Faison's mental disabilities on his credibility. Right? They're not talking about competency, right? They're talking about credibility. So there are, and I believe there are.
Did you want to respond to the government's argument that this was not how you packaged your argument in the trial court?
Sure, and I think where Judge Easterly picked up one is Ms. Chandler obviously asked for it outside of the presence of the jury for a reason. I don't think it has to say, and I'm asking it outside of the presence of the jury for this reason. But two, the trial court at page 17 on the November 1st transcript says, to the extent that her perception is affected by any treatment she's undergoing, I think that's fair game, right? The trial court is clearly understanding this to be relevant both to competency and credibility. That is, again, also saying, I'll allow you to.
Right, but I mean, his point is, but you don't say the thing that seems like you should have to say, which is, I can't really do that in front of the jury, judge. It's going to be, you're putting me in between a rock and a hard place. They're going to hold it against me if I cross-examine this woman about her, mental deficiencies, like, unless I can get a clear sense of what her answers are going to be. So there's it doesn't feel like the judge should be thinking about the thing that you now wish the judge had been thinking about. And I'm not sure the judge wouldn't have gone your way if you didn't say, Judge, think about it this way. I don't have an indication the judge was saying, no, I wouldn't do that. You know what I mean? So I don't really see it as a ruling on the issue in the way that Judge Easterly posited it might sort of, sometimes a ruling can preserve an issue. I don't really see it as a ruling on that issue.
What I mean is that the trial court was interpreting it as relevant to credibility and saying you can do that. Excuse me. You can do that in front of the jury, right? Ms. Chandler had asked to do this outside of the presence of the jury already. I agree that Ms. Chandler didn't say, I'm asking to do this outside of the presence of the jury because it would appear insensitive. Again, I don't think that's. I don't think it's necessary to.
But this, when I'm asking to do this, was to vet her competency to testify. It was not to get a better sense of her mental health conditions so that I can effectively cross-examine without coming off as a jerk.
I mean, given I think it's important, the context, the limited information that had been put forward so far, right, was that she suffered from PTSD, she has an intellectual disability, and that she has also described at times as mosaic Down syndrome, right? I think it's important to understand that this all, came to the court's attention in a span of minutes, right? In the middle of trial, the government says this, and the sort of the procedurally the the threshold in terms of order of operations, right? If she wasn't competent, she couldn't testify at all. And so I agree we didn't get there because the court cut off the inquiry. I see it differently, and I see the court's ruling as saying essentially that the court understanding it to be an attack on credibility, which, and again, the two are closely linked. There are cases of the two being closely linked. I also know that the government keeps describing this as a crisis housing facility. I don't think the record is at all clear that is the government describes it various ways as being a voluntary type situation. We don't hear from anybody, so I don't, to the extent the court is saying, well, maybe it's not as relevant because it's a housing facility as opposed to something that I don't think that's at all clear. And as Judge Easterly pointed out, they knew of the diagnoses for some reason, right? That is the staff members who were there. Just turning back to the sufficiency on the PFCV, the government argued that in attempting to support its argument, the government argued that Mr. Watts was a habitual PCP user, but in terms of the evidence that was in front of to say that he would have been likely to defend himself, but for Ms. Chandler's actions, the evidence was before the jury. Again, going back, Mr. Watts denied using PCP on the date of the offense, and he denied being under the influence at trial. And Ms. Jower testified about this one circumstance in which he used PCP, but I don't think in terms of what the jury could reasonably infer, I don't think there was evidence that he was a habitual PCP user that was before the jury.
But habitual is not really the point, right? I mean, there was evidence that he had used it that night. Right?
Yes, there was evidence. I agree there was evidence he used it at night. I just, the government's characterization was, in their argument here, was that he was a habitual PCP user, and therefore that meant somehow that he was going to,
I mean, I think the notion from growing up in the 80s when this was beaten into our heads was that if you use PCP, you gain super strength at that point. And so it was more that whether he had used it that night. But what about do you agree that evidence came in from Miss Chandler? And I don't remember if the government's point was, if it was pointing to a jail call, but that he was super strong or something like that. Did that?
I don't recall that sitting here, but I can't say that didn't happen. But I would, if I were to guess, I would suspect that was referencing the incident in which she had been choked, as opposed to this. It seems that would have related to that, as opposed to what happened here, where again there was just no evidence of any steps, or that he would have taken any steps to attempt to disarm Mr. Watts. Excuse me, Mr. Tucker. Unless the court has any further questions, we would ask that Ms. Chandler's PFCV and while armed convictions be vacated and the remainder be reversed.
Mr. Madsen, thank you again, Mr. McGovern. We appreciate your time today, and the case will be submitted.
All rise.